I think it went well. I think that unlike what we've seen in a couple of the other cases, you have a judge who understands firearms. I think his questions showed that he understands the nuances of this, making a question about a flash hider. And I think he clearly went through the documents that we provided in our illustrations where we showed that, you can add a flash hider to a 1022. A rifle, we believe, is banned under this act.
The questions seemed very fair, very balanced. Again, it's obvious that he had read the topic. He was obviously familiar with the subject matter. I think the hearing went very well. I think common use is very important. Obviously, the first step is whether the arms are prima facie protected under the plain text of the Second Amendment. Common use is very important. These arms are all in common use. AR-15s are in common use. M1 carbines, some of them prohibited by the Act, in common use. Over 15-round magazines. I can't think of a modern firearm that doesn't use it in excess of 15-round magazine. I think there were good questions from the judge. I mean, the judge had obviously noticed that the state had labeled a flare gun as a grenade launcher, which is a world of difference between a flare gun, which is a distress signal device, and a grenade launcher, which is designed to throw bombs a couple of hundred yards. And there's a world of difference between an anti-tank rifle or an artillery piece and a 50 caliber rifle. Historically, going back to the Revolution, firearms had bore diameters well in excess of 50 caliber. It's just another common cartridge in common use today in this country. Judge McGlynn had obviously read all the briefs. He was obviously familiar with the topic. I did not think much of the state's argument. The state's argument simply seemed to boil down to that the legislature can do what they want. They seem to ignore the Bruin case out of the Supreme Court. I'm optimistic that in the coming days or weeks, Judge McGlynn will enter the TRO that we've all requested.
For us, this means that we reset things back to January 9th. This gives all the individuals the ability to go back to acquiring firearms that maybe they didn't have the money back then to acquire, that they've been saving up and now they want to acquire. A gift for somebody like a son or a daughter that they were planning on buying something for. Or, just as you've seen, we got turkey season going on. You had I-4 issue a press release, and the Illinois Department of Natural Resources is telling hunters they cannot take some of these shotguns out onto public land to hunt with. You've got people who carry Glock 17s. They cannot carry that firearm with a 17-round magazine out in public today. It's even questionable whether or not you can have that magazine loaded inside your car as you're driving down the road. If you have a Glock 17, you cannot walk into any restaurant. You cannot walk into any gas station. You cannot walk into any other private property that's available to the public. And I think that the way they've written the readily convertible language within the magazine component, I think they have actually said that my Glock 19 with a 15-round magazine, because the base plate is removable, is an illegal magazine for me to carry out in public. It's not a 15-round ban. I contend it's more of a 5-round ban. We've seen reductions in 60% or more in some stores as far as what their availability to sell, because it's not just the firearms. It's the components, it's magazines, it's stocks, it's parts. This bill, this law does not allow me to repair a firearm if I don't already have the parts in my house. I cannot buy a detent spring. I cannot buy a barrel to replace a shot-out barrel or any of those other components within this. They refuse to acknowledge how far and broad their ban goes. Because I'd even contend that based under Section 24.1.10 of the magazine ban, the 870 shotgun is illegal for sale in the state of Illinois under their magazine ban.
The weak point in the defendant's arguments boils down to that they're arguing that the legislature is not bound by the Constitution. That's the exact opposite of how it really works. The Constitution controls what the legislature does. The legislature doesn't get to control what the Constitution does.